So again, it's a great honor and a great pleasure to welcome Professor Rachel Harmon to our institute. I will very briefly give you a summary of some Professor Harmon's amazing accomplishments, and then I will get out of the way. Professor Harmon is the Harrison Robertson Professor of Law, and she directs the Center for Criminal Justice at the University of Virginia School of Law. She's one of the world's leading scholars on policing and law, the field of study she helped create. Her academic writings consider how law influences police practices and how federal, state, and local law can make policing more effective, tailored, and less harmful. Her casebook, The Law of the Police, which had a second edition in 2024, is the first to survey the law governing police encounters. And her article on policing have appeared in criminology and legal theory journals as well as law reviews. At the University of Virginia, she teaches courses on criminal law, criminal procedure, and policing. From 2023 to 2024, Professor Harmon served as Senior Policy Advisor for Criminal Justice for the White House Domestic Policy Council. In 2023, Professor Harmon won Virginia's highest honor for faculty at public and private colleges and universities, the Outstanding Faculty Award for Superior Accomplishments in Teaching, Research, and Public Service. She also won the University of Virginia's Outstanding Researcher Award in 2022. Professor Harmon received the University of Virginia All University Teaching Award. She's an elected member of the American Law Institute, who serves as associate reporter for the Law Institute's Project on Principles of the Law Police. She advises nonprofits and government actors and policing and the law, and served as law enforcement expert for the independent review of the 2017 protests events in Charlottesville, Virginia. Before becoming a professor, Professor Harmon spent 8 years as a federal prosecutor in the U.S. Department of Justice, Civil Rights Division, and the U.S. Attorney's Office for the Eastern District of Virginia. The Civil Rights Division, Professor Harmon investigated and prosecuted civil rights crimes nationwide, including cases of excessive force and sexual violence by police officers. Earlier, she served as law clerk to Judge Guido Calabresi of the U.S. Court of Appeals for the Second Circuit and Justice Stephen Breyer of the U.S. Supreme Court. Professor Harmon is a graduate of the Massachusetts Institute of Technology. She received 2 master's degrees with distinction from the London School of Economics as a British Marshall Scholar, and she earned her law degree from Yale Law School. She's going to be talking to us today about understanding the role of commands in law and policing research. And with that, I will get out of here. I will return once the Q&A opens to field questions from here. Other than that, the floor is yours, and thank you very much.
Thanks so much for that generous introduction and for having me here today. It's a privilege to be here and to talk with you and those online as well. As Leo mentioned, I focus on policing and its relationship to law, and I've been working on policing issues for decades, first as a prosecutor in my teaching and research and in policy and reform work. It's unusual for me to have a chance to talk to criminologists and lawyers at the same time, but I'm very glad for the opportunity because my research on policing and law suggests to me that there is a gap between the law governing the police and social science research on policing that's leading us to know less about police-citizen interactions than we should. So with the caveat that I know US law and US policing, my hope is that given the close legal relationship and the fact that criminology crosses borders easily, my comments today will be of broader interest. So I want to talk today about police commands, but just what I mean by that is simply directives given by individual police officers to individual citizens. And my argument is that social science research has overlooked the critical role that commands play in police encounters. So I have 3 kids, and one of them is in part 3 in maths here, so I got to see them this week. But when they were little, one of their favorite books was Richard Scarry's What Do People Do All Day? In addition to exploring the busy town exploits of Grocer Cat and Mayor Fox, the book looks at the activities of police who are, according to the book, quote, working at all times to keep things safe and peaceful. So in a single day, this is Sergeant Murphy, he saves Huckle from drowning, he stops two boys from fighting, he unscrambles a traffic jam, he gives Wild Bill Hiccup a speeding ticket, and he arrests Gorilla Bananas for stealing fruit, all before going home for supper. As Scary reports, people encounter the police when they report crimes or are suspected of them, when they violate traffic laws or when they disturb others, when they ask for help or when they have an accident. And in many of those encounters, officers try to manage how police act. Now, not all policing involves encounters, and not all encounters involve trying to change somebody's conduct. But much of the time, officers want witnesses and suspects to give them information. They want people to move cars or to stop fighting or to back up or to settle down or go on their way or submit to arrest. And so the question is, how do police officers get people to do what they want? Much of the time, they suggest and encourage or cajole and persuade. But if that's all officers did, then they would be social workers or school guidance counselors, not the police. Clearly, the police use strategies other than suggestion to get what they want. So I think social science research on policing has given three answers to the question of how police change behavior. First, the idea that police invoke the law up to and including conducting arrests. Second, the idea that police use or threaten force, whether expressly or implicitly threatening it, up to and including deadly force. And third, the idea that people behave in procedurally just ways such that police are perceived as legitimate, and therefore people voluntarily defer to their authority and do what they want. The qualitative and quantitative work in each of these areas teaches us something important about policing. And yet, all three approaches miss a critical piece of the answer. Mostly, police officers get people to do what they otherwise would not do by issuing lawful commands. Now, it's not that social scientists haven't noticed commands, but today I want to show that they've underestimated and misunderstood their significance. So let me start with arrest. Apprehending suspects to start the criminal process has long been perceived as the paradigmatic form of police coercion. For lawyers, this often is policing. So Blackstone described constables as both duty-bound and empowered to keep the peace by arresting all those who break the law. In this legalistic view, arrests are both the purpose and the power of the police. This view has long been popular in the US, including among police themselves. But in the 1960s, research upended thinking about the police in ways that complicated the picture for the legalistic view. The first systematic field observations of the police were done as part of the American Bar Foundation survey, and they were reported first in Wayne Lafayette's book on arrests in 1965. The survey provided clear evidence, really for the first time, that police officers are not automatons who convert probable cause into arrests, but instead are substantially discretionary actors who determine whether and when arrests occur. Now, legal academics and social scientists responded to this new evidence in dramatically different ways. Law professors, Lefebvre and those who followed him, essentially doubled down on the legalistic view, since they see the primary purpose of policing as criminal law enforcement and arrests solely as a means of starting the criminal process. They viewed this newly discovered discretion in conducting arrests with real suspicion. And they saw arrests for purposes other than criminal law enforcement as legally questionable. This made their research project, really for decades, figuring out how to constrain and control police discretion. Even today, if you read American law reviews, you will see a lot of this approach. Now, social scientists took a very different approach. They built on this evidence an entirely different picture of policing, in which discretionary arrest practices make sense because law enforcement is not the primary goal. Instead, peace officers seek to keep the peace and only occasionally drag someone into the criminal process as a means toward that end. Now, my favorite work in this vein, and I think this is my favorite article ever written about policing, is by Egon Bittner. It's called Florence Nightingale in Pursuit of Willie Sutton, A Theory of the Police. I'll talk more about Bittner's more famous work, his view of policing and force, in a minute. But in this article, his focus is less on force and more on the idea that police exist to respond to exigencies rather than to enforce the law. In this view, criminal behavior justifies arrests, but it is not the reason for them. The reason for arrest is the need to handle an emergent situation decisively, even in the face of opposition. So in this view, the law becomes merely a tool by which police can accomplish something that they otherwise want to do. Now, you can see similar portraits of policing in the work of many scholars in the decades since Bittner. As policing research turned more quantitative, this view developed into a vein of research on police authority, including maybe most famously in work by David Black. Black and many others since describe officers as pursuing peacekeeping through a whole range of strategies that can be graded along a spectrum of legal severity. So sometimes you'll see a 5-point, a 6-point, a 9-point scale. Here, I pulled one. This is from David Klinger's formal arrest scale. He's done work in this area. And these spectrums always start with something like asking questions, moving through suggesting action or negotiating settlements, to imposing solutions with commands. In this one, there's taking reports, and it always ends with arrests. Sometimes, if they're interested in force too. In this view, arrest represents the most formal, the most legal, and the most powerful expression of police authority. And in this work, requests and commands are informal means by which police can change citizen conduct, and they contrast with arrests, which are formal but unwieldy, leaving officers to choose alternatives to arrest most of the time. Now, what, you might ask, could be wrong with this? I want to suggest two problems with this conception of how police change conduct, both of which grow up from the legal role that commands play. First, commands are not informal. They're neither less formal nor less legal than arrests. And second, commands are not an alternative to arrest. Indeed, they're the primary way that arrests and all police coercion is carried out. So let me say more about each of these. First, on the idea that commands are informal action and arrests are formal action. Well, I take the idea to be that commands, unlike arrests, don't trigger a permanent criminal record or immediate physical consequences. But calling a command informal exercise of authority is like saying a criminal statute is an informal exercise of law. When an officer tells you to put your hands up, he's something like a legislature passing a new law. Before he commands you to do so, you have no obligation to act that way. Afterwards, you do. And that command might not create an immediate consequence any more than a criminal statute does when it's passed before you're prosecuted for violating it. Both are binding law. Now, this can be hard to see when you look at police practices because not all commands have this feature. Sometimes a police officer gives you a command that simply reiterates an existing legal duty. So he says to stop, to get off private property, or to stop resisting arrest. And when he does this, when he gives this kind of command, he's not doing anything legally significant. Instead, he's reminding you of that you are violating a legal prohibition, and he's giving you an opportunity, a second chance, really, to comply before you face a ticket or a taser or a trip to jail. But many police commands are not like that. Maybe most of them. They don't reiterate existing legal duties. They create new duties out of whole cloth. So when an officer says stop, he's not telling you something that you already you should know to do. He is making you have to do it. And similarly, when he says put your hands against the wall, these commands are not informal. They create a legal duty to do something. And if you violate that duty, it can result in legal consequences, even if the officer never arrests you. So issuing commands is not informal. It may be the greatest power that police officers have, because arrests change your situation, but commands can change the law that governs it. Okay, so that brings me to the second point, which is that lawmaking commands, this kind of command, isn't an alternative to arrest. If you watch a police officer online, go on YouTube, and you can watch officers conduct arrests all day long, and you will see that they do it by issuing a chain of commands. Stop, turn around, put your hands behind your back, get in the car. We say that an officer arrests a suspect, but really what's going on is that the officer tells what the suspect to do, and then aided by a guiding hand, the suspect arrests himself. Arrest is simply the legal category that we assign to this collection of activities when they're directed at bringing a suspect into the criminal process. But what happens on the street is command, command, command. And it isn't just arrests that are carried out by command. Look at an officer stopping and frisking somebody, or dispersing a crowd, or breaking up a bar fight, or searching somebody's bag. And there are a few things officers have to do themselves, but you will hear the same thing. A police officer might suggest or request or encourage, but when they need to change conduct, overwhelmingly, they tell people what to do, and people do it. Now, one response you could make, and I think it would be reasonable, is to say, look, not all coercion is self-executed. Which brings us to our second account of how police change conduct. Ask anyone on the street, at least in the US, and they don't talk about arrests. They will tell you that officers change conduct by threatening or using force. And most scholars agree. Bittner is actually especially famous here for describing the police as a mechanism for the distribution of situationally justified force. To Bittner and many who follow, policing is not defined by the authority to arrest or detain suspects, but by the expectation that they will use force when necessary to achieve their objectives. As the comedian Chris Rock once put it, if the police have to come and get you, they're bringing an ass kicking with them. What force theorists emphasize is that what makes the police police is that they show up with that power, even if they don't always use it. So following Bittner, social scientists have tried to refine our understanding of how and when and why police officers actually use force, especially in the United States, where force is both more common and a lot more deadly. So to do that, they have analyzed and quantified police coercion as a dependent variable. In early research, the force was just a binary state. There was force or there was no force, or maybe a trichotomy. No force, non-fatal force, fatal force. But since the mid-90s, it has looked a little different. Force has been quantified along a spectrum from least to most severe. The precise marks on the spectrum vary. Here's one from William Terrell, who's done a lot of work in this area. But they inevitably start with no force, and then they move through what's called verbal force, and that includes things like commands and threats. And then they start with low-level physical force, like pat-downs and handcuffs and grips, and then pain compliance in this one, but sometimes they'll just go straight to strikes with the body, and then external weapons, sometimes separating out hard weapons, tasers, and guns. This is from it's a 2003 article in Police Quarterly. So it doesn't matter whether the research is based on surveys or official records or observational studies, this kind of continuum is near universal. And Bittner's view that force is the core of the police function, it goes well beyond the academic circle. So after the 2020 murder of George Floyd in Minnesota, for example, a broad swath of police critics who don't think we should just abolish the police have argued vociferously that what we should do is take from the police tasks that they are not very well suited to do. Tasks like managing conflicts over homelessness or traffic enforcement or responding to many mental health crises. And so the idea is that you can avoid the worst outcomes of policing, in this view, by disaggregating or unbundling the police and reassigning the tasks that you don't need police officers to other actors, government or not. And the idea here is that what police are good at, what they do, their core capacity, this follows directly from Bittner, is things that require violence. I'm not trying to tell you that all this thinking is wrong. No one could think that force is incidental to the project of policing. But I think this view can be misleading. Well, so let's start with the idea that police show up with the power and capacity to use force. Legally speaking, this is simply wrong. When officers patrol the streets, or they answer a call, or they discover a crime, they have a tool belt with lots of statutory powers. But in the first instance, the use of force is not in their kit. They are not allowed to throw a trespasser to the ground or tase somebody because they just stole an iPhone from a senior citizen. Under the law, here as well as in the United States, officers are only allowed to use force if and when something goes awry. So an officer has to attempt a stop or an arrest or a search, and then the suspect has to refuse or resist or threaten or flee. I'm telling you what you already know when I say that if a suspect cooperates or their resistance is feeble, then they may be arrested, but they may not be subject to lawful force. And this isn't a newfangled restriction on police authority. It's been true pretty much since the 14th century. So before that point, a suspected felon could be killed, even if he submitted to arrest. Since then, under the common law, as well as today, an officer cannot break down a door to execute a search warrant unless he first demands entry. I use he because in the United States, it's still true that only about 12% of officers are women. And in policing in the United States, still has a lot of masculinity context associated with it. I know that's less true here, where it's more than a third. An officer can't break open a door unless he first demands entry and is denied. He can't use force in self-defense unless he's first threatened. That's what defensive force means. And he can't use deadly force against a felon who flees unless the suspect refuses to submit. Hale told us in 1847, just about the same time that modern policing started, that an officer can use force only if a suspect resists or flies and cannot otherwise be taken. You might even think that those who say that policing consists of the authority to use force get it exactly backward. Because both police officers and soldiers lawfully use force in the context of their work. But soldiers hit the battlefield allowed to open fire on enemy targets, even if those targets pose no threat to life or to mission. Whereas officers may only shoot when they are defied or threatened. So what distinguishes policing from soldiering is that officers approach their work without the immediate authority to use force. I think relatedly, and this is the second point here, the use of force research gets commands wrong too. So contemporary empirical research on the use of force often treats commands, overwhelmingly treats commands as verbal force, less harmful than deadly force and more harmful than no force at all. But that isn't what commands are, and it isn't what they do. A police command has two components. It communicates what an officer wants someone to do, and it invokes the officer's authority as an officer as a content-independent reason to comply. Now, an officer might invoke that authority implicitly. So an officer is standing in front of you and they're in uniform, and he tells you to put the crowbar down, then that is an implicit exercise or invocation of his authority. You don't need to be told that he's using his authority as a police officer to give you that instruction. You can see it for yourself. Whenever that is not the case, so when an officer tells someone to stop who's running away, or when he comes to your door with a warrant, then officers explicitly invoke their authority. They say, open up, it's the police, stop, police. So you see that these commands are given with this invocation of authority. So if you put this differently, you could see that a command sets a standard for conduct. It informs the person of that standard, and then it tells them with this invocation of authority that the standard is a legal one, that it has legal consequence. If you think about what this means for the role of commands, you can see that if an officer can't use force unless a person is non-compliant, and commands are the way that we set the legal standards that make something compliant or not. So they're what we're going to measure compliance against. That when an officer wants someone to do something that the law does not otherwise require, and he means it, to stop moving or to put your hands up or to get in the car or to keep quiet or to turn out your pockets, if he means it to happen, then he must issue a command. Commands aren't on the spectrum of force. They are an almost absolute precondition to it, except in the most extreme circumstances. Think of an active shooter who knows what he is doing. He shouldn't be doing. Except in circumstances like that, force is unjustified unless officers first issue a command. Okay, that brings us to our third approach to how officers change individual conduct. Because the obvious rejoinder that you should be thinking when I talk about force this way is that what scholars noted in the 1960s is still true today. In the daily work, even if policing does way too many arrests and uses way too much force, it nevertheless remains true that in the daily work of policing, arrests and force are actually pretty rare. Overwhelmingly, people don't resist the police. They do what the police want them to do. Now, decades of scholars largely assumed that this was largely a matter of deterrence, that people did what the officer wanted them to do because they didn't want a criminal charge or a crack in the head. But for more than a quarter century, led by Tom Tyler, scholars, including Professor Takebe, have considered an alternative. That people mostly do what the police want, not because they fear the consequences, but because they perceive the police as legitimate and voluntarily defer. Now, I'm focused really on the procedural justice version of legitimacy scholarship because procedural justice theorists take this idea of legitimacy a step further, and they contend that the police can contribute to the perceptions of their legitimacy and therefore to the deference that they're going to receive by acting in procedurally just ways. Things like giving a voice, showing neutrality, demonstrating neutrality, treating people with dignity or respect, and so on. Now, I can't give quick account of the vast research in this area, not least because it's evolved over the last 2 decades, including in response to criticisms by Professor Takebe and others. But let me tell you the problem I see with this approach when it comes to commands. And this is true even in the most contemporary versions of this. Tom Tyler last year won the Stockholm Prize and has been given a series of speeches, writing papers, continuing to express where we are in the state of procedural justice research. And I think the criticism continues to hold. So you have to understand that when he started, he was building on work, actually including by one of my colleagues, that were focused on procedural justice with respect to courts, the way we perceived our treatments in court. And he was focused initially on the idea that procedural justice could influence compliance with the law, by which he largely meant statutory law, and in particular, criminal statutes. So if people were treated, this was the hypothesis, in procedurally just ways, then they wouldn't violate criminal law as often. Quickly, though, Tyler extended his analysis to compliance with police directives. That was like the most natural arena for him to focus on. And when we're talking about directives, we're talking about commands, but they're usually called directives in this work. And since then, much of the research has considered whether procedurally just treatment of individuals leads them to obey the police. Now, over time, as procedural justice scholars dug into policing, the scope of the positive outcomes that they started to hypothesize procedural justice could produce expanded further. So for more than a decade, the research in this area has commonly included not only adhering to statutory law and complying with police commands, but also agreeing with police requests, providing the police information, and proactively calling the police for help or to report, particularly to report crimes and suspicious behaviors. And sometimes all the research combines all of these positive outcomes in a soup of results that count as deference or obedience to the police. Now, you can see why procedural justice theorists would move to this expansive idea, because since Robert Peel, it has been widely recognized that policing a democratic society requires cooperation from the public, because otherwise you would need far more coercion to make the project go than the populace would be willing to tolerate. And so, in the procedural justice view, if procedural justice produces really voluntary, value-sharing, deference, and not just obedience from a fear of consequences, well, then cooperation and compliance, cooperation with requests, compliance with commands, they look like two sides of the same coin. The ideal in Tyler's work and in others is a world in which we all contribute to a safe and orderly society by engaging in a range of pro-social behaviors, especially following the lead of the police. Now, there's much to like in this consensus vision. There are certainly criticisms of this vein of scholarship for having a vision that maybe focuses on the obedience and deference and legitimacy of some parts of the population and not others. But I don't want to talk about the criticisms of the traditional criticisms of this work today. I want to suggest that as a lawyer, I think procedural justice scholars may be misconstruing the structure of our collective pursuit of safety and order. When an officer is lawfully authorized to issue a command to tell me what to do, then the political processes of the state have determined that the officer is in a better position than I am to decide whether a change in my behavior is the best means of, in this consensus view, of producing public safety and order. So an officer tells me that he has made this determination by giving me a command. If I view the police as legitimate, I'll defer to that directive as deserving of my obedience. But when an officer, by contrast, doesn't have the power to issue a command, then the state has determined that I am better positioned to make the assessment. The officer is still free to make suggestions, but I might well believe that the officer deserves my deference, that I trust his decision-making and his motives, that I share his values, and still not agree to his request to look in the boot of my car. Because I know that in the absence of cause for that search, which would give him the power to issue a command, then I may be better able than the officer to assess whether my time today or my privacy is more valuable than the search's likely contribution to public safety. So even from this consensus perspective, I am not necessarily expressing distrust. I am fulfilling my role in contributing to public safety, which includes considering and knowing my individual concerns that the officer cannot know, and that in this scenario may not be overcome necessarily by other interests. I similarly think that that I might think the police are legitimate and still have views about how they should best contribute to public safety. So I might think that police officers should not make arrests for very minor crimes. That's something that they might have discretion to do, but I don't think they should do it. Now, in the United States, we have robust debates about this as a matter of state law and also a matter of police practices. So one of the most common bases for arrests for decades in the United States was minor amounts of marijuana possession. And now 29 states say you can't make an arrest for that. It's no longer illegal. 21 states say it is, and you can't. Now, I might live in one of those states and think, that's a terrible idea. Let's not do that. Or similarly, I might think, you know what? Officers in my community believe that a level of disorder should not be tolerated if it's noisy or disruptive to anyone. But you know what? I come from San Francisco. Actually, I come from Brooklyn. I think there should be a lot of disorder in the world, and I want my police to act accordingly. Now, I might, in a world in which I know police have discretion, express my views about how they might exercise that discretion if I were a little bit younger, by following them around with an iPhone and commenting on their work, okay? And saying, hey, don't bother that guy, he's not doing anything, right? I might still, that doesn't mean that I don't believe that police are legitimate, and that if an officer gives me an order to shut up or back up or walk away, I might follow that order. Because that lawful order would convey to me that in this scenario,
we have decided collectively that it's not in society's interests for me to pursue my policy agenda in this way at this time. But that doesn't mean that I will also cooperate with requests or volunteer to call the police when someone is being noisy, or otherwise promote strategies and policy agendas with which I disagree, which I wish were otherwise. When we don't make a law or don't allow a command, we're signaling that that conduct that I might engage in order to express my views on balance isn't in conflict necessarily with the community efforts to produce public safety and order. Now, an officer could suggest to me that that's not true, and I might be persuaded, but this is all to say that I might happily defer to commands and still not agree with requests or initiate conduct and still respect the officer's authority and defer when I am commanded to do so. That is similar to how I follow the criminal law. I don't assault my neighbors because I respect the criminal law, but that doesn't mean I'm going to invite them over to dinner. I think legal limits mean something in a thriving cooperative society. I think they signal something to the people to whom they are given, and complying with and cooperating with and initiating with contact with police aren't all the same thing. Now, procedural justice researchers could persuade me that I'm wrong about all this, that actually people don't work the way I say they do, and they don't distinguish among these different activities when they perceive the police as legitimate. But I'm not going to be convinced so long as they don't pull apart these outcomes, either in their theories or in their research, and make room for other possibilities. There's another problem I see with the procedural justice work as well. It's that if legal limits on policing matter the way I think they do, then neutral, trustworthy, respectful policing would clearly distinguish whether something is a request or a command, because I need that information about the situation in order for me to understand how to best pursue the public's interests. I need to know, for example, whether I should take myself to be the best arbiter of what it needs to be done for public safety, or whether I should defer to the officer. But because the research doesn't really maintain this distinction, procedural justice training for police officers that is a product of this research doesn't either. So officers are often trained in procedural justice trainings to be polite, and then are told that one way to be polite is to frame things as a question, as a request, even when they mean it as a command. If my view is right, then this is obscuring necessary information that we need in interacting with the state, and denying the public what they need to know to understand how they should behave in interaction with the police. Okay, so where are we? I've argued that lawful commands are central, in fact, essential to policing. And yet, social scientists have largely studied commands only in passing. That means we don't know very much about them. Among other mysteries, we don't know when or why or how often officers give commands, either within their local lawful authority or outside it. There's this huge gap between the significance of the legal significance of commands and their role in social science. Now, you could see this as part of a broader problem, at least in the US. There has been a long-standing separation between those who study the law in policing and those who study policing using social science methods. Today, I'm talking about the social science research, but I've harassed the lawyers before. I think this separation leaves both sides worse off. Luckily, we're in a new era in policing research. an era which makes systematic social observation far cheaper, far easier, and far more reliable than ever before because of body-worn cameras and natural language processing. This era seems especially well suited for commands. So if I had given this talk 10 or 15 years ago, I think people would have looked at me and largely shrugged, because what were they going to do about it? Now, I hope that we can say much more about commands because we have the opportunity to do so. But that won't happen until I persuade you and maybe other people who are studying the police that the project of studying commands is worthwhile, much more so than criminological history would suggest. Thanks very much. I look forward to your thoughts.